The next part of the rules that we're going to discuss are the different roles of lawyers. Here, this subsection of our rules makes up 4 to 10% of our total MPRE exam. So first things first, I want to explain that lawyers can wear many different hats, so to speak. As an attorney, you might find that your role is that of an advisor, or you might find that your role is that as an evaluator, or maybe you're acting as a negotiator, or as an arbitrator, or as a mediator. And there are different rules that speak to each of these types of hats or roles that we could play when acting as a client's attorney. I want to discuss first by talking about our role as a negotiator. So here the rule specifically says that a lawyer must not make a false statement of material fact when the lawyer is acting as a negotiator. So say you are trying to settle your client's claim. Maybe you've already filed the lawsuit, but your client really doesn't want to go to trial. So you're trying to reach some sort of favorable settlement. And obviously you can do that. That's you acting as your role as a negotiator. However, when acting as a negotiator, you cannot make a false statement of material fact. This means that you cannot lie. If you know for certain that, say, your client's medical expenses are $50,000, you cannot state that your client's medical expenses are $150,000, because that would be a lie. That would be a false statement of material fact. However, the rule then goes on to state that the lawyer can engage in what we call puffing or puffery. For instance, the lawyer can estimate some sort of settlement value, or can engage in puffing when it comes to their client's intention to settle. So for instance, if I am acting as a negotiator on behalf of my client, and I know for certain that my client does not want to go to trial and would really like this lawsuit to settle before then, while negotiating on behalf of my client, I can tell opposing counsel that my client has no problem going to trial if necessary. So while that's obviously not my client's intention, and my client really doesn't want to go to trial, that is considered puffery or puffing. I can make them believe that we will go to trial and have no problem doing so, even though my client really doesn't want to. That might lead us to, say, settling this before having to go to trial, and that would be ethically permissible. So there is a difference between engaging in puffing or puffery and making a false statement of material fact. So you cannot lie when it comes to material facts and misrepresent things. However, when it comes to negotiating, you can engage in puffing, which is, again, say, estimating a settlement value, or a discussion as to whether or not your client intends on settling or going to trial. And then lastly, a lawyer has no duty to volunteer facts that are unfavorable to their client or to correct any misapprehension made by the other side unless the lawyer or the lawyer's client has created it. So again, if your client's lied or if you've lied, you have to correct those statements. However, if the other side has some sort of misunderstanding that you did not create, you do not have an obligation to fix it. And you also do not have an obligation to raise information that harms your client when acting as a negotiator. Moving on to lawyers acting as an arbitrator, mediator, or otherwise a third party neutral. So first things first, let's define what we're even talking about. A lawyer serves as a third party neutral when the lawyer is assisting two or more persons who are not clients of the lawyer to reach a resolution of a dispute or other matter that has arisen between them. So you're third party neutral when you are not plaintiff's attorney or defense attorney. You are just trying to help them solve or reach some sort of reasonable settlement of their issues. So what is the rule in regards to this? It says a lawyer serving as a third party neutral shall inform unrepresented parties that the lawyer is not representing them. When the lawyer knows or reasonably should know that a party does not understand the lawyer's role in the matter, the lawyer shall explain the difference between the lawyer's role as a third party neutral and the lawyer's role as one who represents a client. So again, the obligation is on that third party neutral attorney to make it really clear their role in the matter, and if there's any confusion as to their role in the matter, they're clarifying that as necessary. And if this third-party neutral is asked to serve as a lawyer for one of the parties, the lawyer may only do so if all of the parties gives their informed consent in writing. This means that if you are the third-party neutral for a plaintiff and a defendant, and then after the fact, plaintiff wants to hire you as their attorney, you can only do that if both plaintiff and defendant give their informed consent to this conflict of interest, and that is confirmed in the signed writing. Additionally, this conflict of interest is imputed to the lawyer's whole firm, meaning anyone in their law firm cannot take on this matter unless the lawyer is appropriately screened off of it to avoid that conflict of interest. The one exception to this rule, which is outlined in more detail in the conflicts of interest portion of your outline, is when you are acting as a partisan arbitrator. So again, if you are, say, plaintiff's arbitrator or defendant's arbitrator, you can obviously represent the plaintiff after the fact or the defendant after the fact, because we all know whose side you are on. If you are defendant's arbitrator, you've been hired by the defendant. So again, that would mean you are not a third-party neutral. So that's the exception to this rule. There's a difference between a partisan arbitrator and a third-party neutral. The difference being is the neutral should be neutral, and the partisan arbitrator isn't neutral. The next rule that I would like to discuss is a lawyer appearing in a non-adjudicative proceeding. So here the rule says, a lawyer representing a client before a legislative body or administrative agency in a non-adjudicative proceeding shall disclose that their appearance is that in a representative capacity. It's helpful to understand the rationale behind this rule. Much like representing a client in court, when the judge and the whole tribunal should be able to rely on you for not lying and for accurately representing the law and the facts, this non-adjudicative body should also be able to rely on you to not lie and should be able to understand what type of role you are playing in the matter. So if you are there representing a client, you need to let them know that you are there in your representative capacity so that they understand the role that you are playing. So for instance, let's say a lawyer was hired by a gun rights organization to argue against proposed gun legislation in a hearing. Lawyer presented arguments against this legislation at this hearing. The lawyer must disclose that she is acting in her representative capacity. The next rule that I would like to talk about is a lawyer who represents an entity or other organization. So again, this would be the scenario where lawyers say representing a corporation. A corporation is not a person, but they're ran by people. And this can obviously cause some confusion for a lot of people preparing for the MPRE. So this is an excellent rule to go over. So here the rule says that our duty of loyalty runs to the organization if you are a lawyer for it. So this means a lawyer owes their duty of loyalty to the organization and not the people who run it. So again, if you are the attorney for a corporation, your duty of loyalty is to the corporation, not to the board of directors. There is a difference, so it's important you understand that. The rule goes on to say that when you are dealing with the organization's directors, officers, employees, or members, or any other constituent, a lawyer shall explain their identity of the client when the lawyer knows or reasonably should know that the organization's interests are adverse to those of its constituents with whom the lawyer is dealing. In other words, the lawyer has this obligation to make it clear to people, whomever they are dealing with, that their duty of loyalty runs to the organization. And it's important that they do this when they're dealing with people whose interests might not be aligned with that of the corporation, so that there is no confusion about the role in which the lawyer is playing there. So turning to an example, let's say a business manager admitted to the general counsel that he had used threats of violence and defamation in order to help maximize the profits of the organization. The general counsel should remind the business manager that he represents the corporation and not the manager personally, and that threats are illegal, and that the business manager might need independent representation in the matter. When it comes to a lawyer's duty to report when representing an organization, say like a corporation, the rule says that if a lawyer for an organization knows that a person associated with the organization is acting or is going to act in a matter that is in violation of a legal obligation to the organization or is in violation of law, that reasonably might be imputed onto the organization and that it is likely to result in some sort of substantial injury to that organization, then the lawyer shall proceed as reasonably necessary in best interests of the corporation. Because again, the lawyer's duty runs to the corporation. The rule then goes on to state that unless the lawyer reasonably believes that it is not necessarily in the best interest of the organization to do so, the lawyer shall refer the matter to the highest authority in the organization. It's usually the board of directors, including, if warranted by the circumstances, to the highest authority that can act on behalf of the organization as determined by applicable law. So for instance, this could be the circumstance where there's an outside board of directors, and the attorney could then report to them regarding the circumstances. So turning to some examples here. First and foremost, let's say a constituent has an innocent misunderstanding of the law and takes lawyer's advice when notified of this. The lawyer may reasonably conclude that the best interests of that organization does not require that this matter gets referred to a higher authority. The lawyer could reasonably conclude that that was an innocent misunderstanding that got clarified, and that's it. Our second example, let's say a constituent persists in conduct that's contrary to the lawyer's advice. The lawyer must then take steps to have the matter reviewed by a higher authority in the organization, because then the lawyer should have knowledge or should reasonably believe that it is necessary to take more action to protect its client. Moving on to the portion of the rule that discusses reporting outside of the corporation. So here the rule says that if despite the lawyer's efforts, the highest authority that can act on behalf of the organization insists upon or fails to address in a timely and appropriate manner an action or a refusal to act that is clearly a violation of law, and the lawyer reasonably believes that the violation is reasonably certain to result in substantial injury to this organization, then the lawyer may reveal information relating to the representation, whether or not the confidentiality rule permits such disclosure, but only if and to the extent the lawyer reasonably believes necessary to prevent substantial injury to the organization. So just to recap this, as an attorney for an organization, say a corporation, you have an obligation to report up if you figure out that something is happening that could harm your client. Usually that means reporting up to the board of directors. But let's say reporting to them doesn't do anything, or maybe they tell you that they are not going to take action for whatever reason. Maybe it's some sort of criminal action that they are taking part in. Then under those circumstances, if you believe that some sort of substantial injury is going to result to your client, that corporation or that organization, whoever you're representing, then you can report out to try to protect your client. This is true even if that means you have to divulge confidential communications or information relating to your client. But again, you should only divulge as much information as is necessary to protect your client or to correct this issue. There is one exception to this rule I want to bring to your attention, and it specifically says this rule shall not apply with respect to information relating to a lawyer's representation of an organization to investigate an alleged violation of law, or to defend the organization or an officer, employee, or other constituent associated with the organization against a claim arising out of an alleged violation of law. So this basically means if you are hired as an attorney to say, help a corporation investigate some sort of alleged violation of law, and you investigate and you do your fact finding and you do determine that there has been a violation of law, you can't go tell that organization or corporation because you've been hired by them to investigate to see what happened. So you cannot report out under those circumstances because you were hired by them to investigate and to protect them in this action, not to tell on them. So that is the difference there. That wraps up that subsection of our rules, and we're going to move on to the next part.